Hi, everybody. As you know, I am Ina Santiago. I am the founder and CEO of Girls Rule the Law. So if you're watching this video, that means that you are preparing for the final round. So congratulations for getting this far in the competition. So as you know, there is a lot that goes into the competition and what the grading system is for the final round. Since you have already gone through the first round, you understand that things move very quickly as you're competing. And sometimes you don't have time to think about some of the things that you need to think about as you are competing. So I want to use this time to remind you of the grading system that is being used during the competition. So you are given points from 1 through 5. And it's based on preparation. It's based on how you are carrying yourself. It's based on professionalism. It's based on objections, whether you know and recognize the rules of evidence as the case is going on and as the witnesses are testifying. And also your projection. Can the judges hear you? Do they have to tell you to increase the volume of your voice, right? To speak up? Do they have to tell you to slow down? Are there words that are not coming through that the other side has to keep saying, excuse me, or I don't understand? So be mindful of your cadence, be mindful of your projection, and of course, be mindful of the emphasis on certain words. We've been working throughout the past 12 weeks now. I have been explaining to you about certain ways that you can make sure that the judges are listening to certain points that you're making. One of the ways that you do that is through emphasizing certain words. When you emphasize certain words, when you pause before a word, when you pause after a sentence, just 2-3 seconds after that sentence, it makes the reader psychologically listen and sort of absorb more of what you're saying. So when it comes to the rules, point 1 is ineffective. If the judges find your arguments ineffective or the way that you're delivering your argument ineffective, you will get 1 point. 2 points is fair. It's minimal performance and preparation. Remember, we've been speaking about that as well. For especially the witnesses, this is a performance. For Maria Rosa, you are Maria Rosa. If you are the caseworker, Jane Thomas, you are the caseworker. If you're the professor, constitutional law expert, you are that character. And the same thing for Dr. Bailey, the history and economic professor. So it shouldn't come along as scripted. It shouldn't come across as scripted. It also shouldn't come across as monotone. You will lose points for monotoneness, right? So you should have absorbed that information and made that character your own. So for Maria Rosa, you know that, yes, you are devastated that this is happening to you. You're upset that you are in Puerto Rico and you don't have money from the federal government because now they're not only taking away your Social Security disability benefits, they're asking you to pay back money that you just don't have. And for Jane Thomas has to be extremely matter of fact, but she's a caseworker. She had a relationship with Maria Rosa. So Jane Thomas should be speaking from a place of, yes, I'm very familiar with Maria Rosa's case because I handled it. Yet it's not personal. Right? I'm not trying to hurt Maria Rosa by taking away these benefits. I'm simply following the law. And she was aware of what the law was because I told her. It was part of my job to tell her, and I did it. For the experts are, you're also, again, embodying this person, but the experts are extremely matter of fact. They are professionals. They are academics. They have a lot of knowledge. So when you are on direct examination and you can follow your affidavits, that's great. But the challenge is going to be on cross-examination. So what do we do to prepare for cross-examination as an expert? You have to review the other expert's affidavit. Now, the thing in cases is that you almost always have what we call dueling experts. That means that one expert is going to contradict what the other expert says. It's no different in this case. So for these particular cases, the economic and history expert should have reviewed and is very familiar with what the constitutional law expert is going to say and vice versa, because they have to be able to withstand a challenge to their knowledge with the words of that other expert. So at this point in the competition, you should have done that. But if you have not, you have the next couple of days to try to absorb that information, and I would urge you to do so. The worst thing you can do on cross-examination is to have a string of I don't know, I don't know, I don't know, especially as an expert. That may work for the lay witnesses, but not for the experts. The experts need to be able to actually respond to a question and actually confirm what their position is, and then tell the judges and the lawyers why their position is correct. So if they're asking the history expert, for instance, well, math doesn't lie, right? If there's no money going out, then if there's no money coming in, how can there be money going out? That expert needs to be able to respond, no, math doesn't lie, but semantics does, right? So if you're saying that you have no money, that's one thing, but we've proven to you that Puerto Rico actually pays $4 billion every year into the government. So the statement that there is no money is a lie, is a falsehood, it's not true. And you have to be able to push back strongly like that, because it lends credibility to your argument as the expert witness. Okay, so that's that. 3, if you're unable to apply the facts creatively, you're only going to get 3 points out of 5. And that's exactly what we're talking about, right? You have to have an understanding of the facts of the case and then be able to apply them when you are challenged. So if you cannot do that, if you keep saying, I don't know, especially on cross-examination, you are going to lose points. You want to get as many points as possible. Doesn't demonstrate a mastery of the case, but grasps major aspects of it, right? So that's still number 3. We don't want that. We want you to show that you have a mastery of the facts and you have a mastery of the case, right? And that, again, you can actually apply some of these cases, these things that they're throwing at you on cross-examination, and use it to actually bolster your case and make your case stronger. So very good is 4, and that's that the presentation is fluent, it's persuasive, it's clear, and it's understandable. The student is confident. And I know that it's hard to be confident when you're doing this for the first time in your life, right? We've been doing it for 12 weeks, but this is the first time in your life that you're doing these sort of mock trial thing. Now, I understand it's hard to project confidence, but please try to come up and have a strong voice, and don't nervous fidget, right? Be mindful of that. You have to handle your questions well, objections well. You need to be responsive to the questions. I know that for some of you, you may be using scripts. Leave the scripts behind for Friday. And the reason for that is that if you get an answer to a script that may be different from what you practice, is going to throw you off. So leave the script behind and actually listen to the answer so that you can follow up on the answer, okay? So if somebody gives you a 2-part answer, you know that you have to break it down and follow up on those, as opposed to moving on to your next question. So you need to recover quickly from minor mistakes. We have been speaking about that throughout these last 12 weeks. Sometimes when you ask a question and it's not the question you want to ask, or if there's an objection to the question, you may get thrown off and say, like, oh, I'm sorry, or withdraw. Try not to do that, okay? It happens to the best of us. Even lawyers in real cases, people who have been practicing for decades, still get thrown off from time to time, right? If it's a question that there's an objection to it, and you genuinely feel that you cannot justify that question, you cannot respond to that objection, that is perfectly okay to say withdrawn. I'll ask another question, Your Honor, and then try to come at it in a different way, okay? But don't withdraw simply because there's an objection to it and you're too nervous in the moment to come up with a response to the objections. Now, how do you respond to an objection? You all have been hearing me say this for the past 12 weeks. The best response to the objection is usually the most obvious one. So if someone has a relevancy objection, your response is, it's relevant, Your Honors, because, and explain why you asked the question. If you asked the question, you had a reason for it. It's perfectly okay to explain what your reason was, right? If your question is some sort of background information, right? How long did you work, Miss Rosa? And they say, how relevant is that? That's irrelevant. Then your response is, it's relevant, Your Honor, because I'm asking background information before we get to the question about these SSI benefits, right? So the obvious response, the same thing with hearsay. If they say, and remember, hearsay is when you hear somebody say something. When you're asking, the question is asking someone to say, what did somebody else say? What did she tell you? What did you hear him say? You know that's a hearsay objection. The response to the hearsay objections, and again, I expect you to have looked in your packet, but the simple response is, I am not asking for the truth of the statement, Your Honor, but for the fact that it was said, right? That's the easiest response, because the hearsay objection is that you're trying to prove a point or a fact by saying, what did that person say by that statement? So the response is, I'm not asking for the truth of the statement, but just for the fact that Maria Rosa said it or Jane Thomas said it, right? And then that's your response. What else? Your presentation needs to be both believable and skillful, right? It doesn't matter if you are skillful, if you can speak, and it's great if it's not believable, right? I think we had some of those issues the last time when some of the judges complained that the arguments made, one of the judges complained that the arguments made by the government was not believable to her based on her experience, okay? Now, it's not our problem, and it's not our purpose to make sure that every judge likes us, right? Some judges are gonna come with their own biases and they're not gonna like what we have to say. But it does have to be believable from a legal standpoint and from a lawyerly standpoint, right? So you don't want to be obnoxious. You don't want to come across as if you're lying. It has to be believable. It has to be earnest. It has to be clear. And then, of course, 5, excellent, is if you're able to apply the case law and statutes appropriately, if you're able to apply the facts creatively, especially on cross-examination. Are you able to present analogies to make the case easy for the judge to understand? I think both of our teams in the finals have been able to do that. So outstandingly well prepared and professional, right? Good sportsmanship. You're not interrupting the other side, right? You're not making faces. You're not doing anything that's going to be considered unprofessional. You're supremely self-confident. You're keeping your poise under duress. Again, we understand that you are all students, you're scholars, you're not grown-ups, and we don't expect you to have absolute perfect poise, but we do expect you to show confidence. You have been practicing this for a long time, and you should be able to do that. You think well on your feet. Again, we're not following a script. We are able to follow up on questions. We are able to see when a monkey wrench has been thrown into something, right? Every once in a while, something will surprise you. One of the witnesses will come up with a novel idea to try out on the stand, okay? You can't be surprised by it. You have to roll with the punches. Now, your presentation was resourceful. It was original. It was innovative. It made the judges think. You can sort out the essential from the non-essential and use this time effectively. Now, remember, you are going to have 5 minutes for your opening statements and 10 minutes for everything else. So you don't want to spend your time on things that are not going to help you. So stuff like a whole bunch of background information or stuff that's irrelevant, you don't want to get into it because you're going to run out of time. And time goes very quickly when you're doing these mock trials, as you have now seen. Outstanding responsiveness to questions and objections, handles questions from judges and attorneys in the case of witnesses extremely well. Now, what didn't happen in the first round, and that will absolutely happen in the second round, is that you are going to get questions from the judges. You are going to have judges interrupting you, especially in the closing arguments. And the reason for that is, again, to check your poise, is to check your confidence in the arguments that you're making. You are going to have 5 judges for the finals instead of 3. You are also going to have 2 people, senior people from the Department for Youth and Community Development, and they are also going to give you feedback. You are going to have about 12 jurors who will be sitting in the jury box, and they will be deciding as well how well you did, right? The ultimate decision is going to come from the judges, the same way that they did before. You're going to rest, and they're going to go behind and they're going to deliberate, but you are going to be hearing from other people. So it's very important to learn how to handle those questions. And again, it's okay to take a moment to pause, gather your thoughts before you answer the questions. And then the number 5, excellent, is knows how to emphasize vital points of the trial and actually does so, right? So especially for the closing argument, you need to be able to pull all those things out that were said by the other side in real time, right? Not what you've rehearsed, but in real time. If something new comes up, you have to be able to incorporate it and then emphasize those points to the judges before the end. Overall, the team is going to get judged as well. So it's not just going to be the lawyers. They are going to be checking for the confidence, preparedness, demeanor of the entire team, compliance with the rules of civility, zealous but courteous advocacy, honest and ethical conduct, knowledge of the rules of the competition, and absence of unfair tactics, such as repetitive, baseless objections, improper communication with signals, invention of facts, and strategies intended to waste the time of the opposing team. So those are the rules. And again, you have all done such an amazingly wonderful job so far. I have no doubt that you are going to do an amazing job in the finals. So this is it. There's light at the end of the tunnel. Keep practicing, keep practicing. The cure for being nervous is to be prepared. Everybody gets nervous. The judges get nervous. Attorneys get nervous. People who have been lawyers for decades and decades still get nervous before a very important trial. So we ask you that if you feel like you're nervous, then just prepare. Review your materials even more. Review with your teammates. And it's almost done. You have a few more days. And then after that, you're done. So I hope this has been helpful. If you have any questions, please ask your instructor, or you can email me directly if you have anything that you need to know or you need work on. I'm happy to hop on a Zoom with any of you between now and Friday. Okay, good luck.